Good evening here with Kevin Schofield, SCCinsight.com. It seems like I talk to you more and more often, which usually means it's something with city council or the courts.
Words.
Today it's the courts. There is a real credible filing today in the federal courts against Mayor Durkan as the mayor and Jay Inslee as the governor of the state of Washington. And it looks like there's a group that's trying to halt the rent moratorium, right?
Yeah, the eviction moratoriums. Right. So there are eviction moratoriums that were put in place by Governor Inslee, by the mayor, and then the city council came in and extended the one that the mayor put in place, having to do with the COVID situation. And so this group, the Pacific Legal Foundation, on behalf of a handful of landlords, filed a lawsuit today challenging the legal basis for those eviction moratoriums, saying that the governor and the mayor and city council have overstepped their powers in doing this. And and it's an interesting case. And this is one, take a deep breath, because this is one that's going to make your brain hurt. It made my brain hurt spending a few hours just digging through.
My brain's been hurting for months.
Well, get the aspirin out, because this is one where I spent hours just chugging through all of the case law, or a good chunk of the case law around this, and going back 100 years or more. And it's an interesting, complicated set of stuff around this. So I can say just at the beginning, the plaintiffs have chosen the landlords that they're including in this very carefully. There's one here who manages several units that he rents to low-income tenants at below market prices. So going for sympathy there. There's another one who has only one unit that he manages, and his tenant has been consistently employed through the COVID emergency, but even going into well into last year, was a bit of a flaky tenant and was really not good at paying rent on time. And this landlord apparently issued like half a dozen pay or vacate notices to this one tenant between last August and this February. And then the eviction moratorium happened, and the tenant isn't paying his rent now, and the landlord can't do anything about it, right? So they're definitely going for the sympathy vote a little bit with some of the landlords, but they're also choosing them with some diversity to kind of explore some different aspects of the law as it relates to this. So
it's not that big corporate, a lot of times people like the big corporate landlords. These guys specifically chose like small landlords, individual.
Yeah, and there are a couple involved that are slightly bigger landlords too, sort of in the dozens of properties, but it's not big corporate hundreds of units. It's smaller ones than that. Now, the heart of this, that they're challenging it based on two parts of both the U.S. Constitution and the Washington State Constitution that have essentially the same language in both. And one of the two is what's called the takings clause, which is about property and whether the government can take your property away from you. And by taking, and the Constitution says the government can't take your property without compensating you justly for it, right? And both constitutions say that. And what a taking means, it could be in a bunch of different things. It could mean literally they take possession of your property away from you. It could also mean that they prohibit you from occupying your property. Or it could be that they do what's called depriving you of the economic value of your property, meaning, you can't rent it out for money, right? Your property, if you own a piece of land that has some economic value, either because you can develop it and like have a factory on it, use it to generate, income, or you can rent it out or things like that. So that's sort of the economic value of it. And if the government deprives you of that economic value, then that's also a form of taking, right? And if they're going to do any of that, they have to compensate you. And so what they're saying to that is because they're basically saying you can't collect rent and you can't evict a tenant in favor of bringing in a new tenant who will pay their rent, that they're potentially depriving these landlords of the economic value of their property. So then the other constitutional right that they say this deprives is a more complicated one, and both the U.S. Constitution and state constitutions say that the government may not impair contracts, right? And you know, if you've ever seen Hamilton, then you know that this is something that was in the Constitution from the beginning. It wasn't kind of a late stage amendment to it. If you've seen Hamilton, then you know that the finances of this country were a complete mess at the beginning, right? And for some business owner who had a contract that maybe even extended before the beginning of the United States, right? Seeing this new government try to put itself together and its finances are a mess, and as it's passing new laws, it could pass a new law that was different from the British common law that might have called into question the validity of a contract, right? That pre-existed. And a lot of people were telling the government, hey, you can make a bad situation even worse if you do things that suddenly make the economy run based upon all these contracts, everything we have in place, just fall apart. And so they wrote in the Constitution that the government may not impair contracts, just to give assurance to a bunch of these folks that, okay, what you're doing is still going to be okay. We're not going to pull the rug out from under you, right? This has come up in interesting context. It came up recently in the context of Initiative 976, Tim Eyman's most recent $30 car tab thing, because one of the counties that sued to challenge that had issued transportation bonds with a written promise that they were going to pay them back based upon the revenues they get from car tabs, right? And so Initiative 976, because it got rid of those car tabs, impaired their contracts for those bonds. So they're challenging that, and there's precedent for saying that same thing happened with Tim Eyman's first $30 car tab initiative. That's one of the reasons that got thrown out, because that impaired these contracts for bonds, right? So it's not just an ancient law, it's actually a very real present one that's being used today. So what they're saying is, hey, look, there's in our rental contracts, these landlords are saying there's requirements for them to pay the rent, right? And for interest and late fees and things like that, that landlords have the right to evict tenants who violate the rules or don't violate terms of the contract. And they're saying this moratorium actually impairs those terms of the contract. Okay, so on its face, it's like, yeah, that has some merit, but there's 100 plus years of history, nationally going back to the Great Depression and before, and locally, I found a really sort of on point, relevant, case related to the eruption of Mount St. Helens, right? When the governor actually basically called for an evacuation of a whole town and surrounding area right at the base of Mount St. Helens, right? Which basically shut down a whole bunch of businesses in that in that area. And so there's both local and federal case law talking about these issues of, well, so under what circumstances can the government actually restrict or constrain these constitutional rights, like the takings and impairing contracts? And and it's very complicated because the Constitution doesn't say the government may restrict these constitutional rights under these situations. But what the courts have said over the last 100 years, really starting going back to the economic emergency that was the Great Depression, was there's kind of an implied constitutional responsibility for the government to maintain public health and safety, right? And so if and that can at times trump impairing contracts and that's why the government is allowed to call a curfew, right? and you know, and under
So would the
circumstances.
government's defense on this be something like, well, we're immune for this because our actions were in the public safety?
Yes, and in
How do you
fact,
see them?
yeah, and in fact, if you read the government's executive order, the governor's executive order, the mayor's executive order, and the legislative extension to the mayor's moratorium of the city council, you're going to see in all of this magic catchphrase, which is, some form of preserve and protect public health and safety, because that's the thing that connects it back to these legal cases that says, the government can restrict these constitutional rights if they need to protect public health and safety. Now, in this case, that's a really strong case because we had both COVID, a major public health pandemic, right? And the economic fallout, which is still, and both of those are still going on, right? So just from a 30,000 foot point of view, the government has a really strong case on both of those that, hey, we have the right to go do this. But where it gets weird is this question of, yeah, but it's, and the courts have said this too, it isn't completely unconstrained, right? So, if the government did a 1 month moratorium on evictions, everybody would be like, yeah, sure, that's fine. If they did a 10-year restriction, moratorium on evictions, everybody would be like, okay, that's too long. You can't say, that tenants, if they don't pay their rent for the next 10 years, the landlords can't evict them. That's just crazy, right? So, but somewhere in between there, it's like you hit this kind of threshold of reasonableness. And, and by the way, judges hate that, right? They hate having to be put in a position of saying, okay, you can have this moratorium in place for 11 months and that's cool, but 12 months, no, that's just too long, right? Trying to determine, ask a judge to determine what the threshold is for reasonableness around this. They hate doing that sort of stuff. But that's probably what a lot of this is really going to come down to. Is like, okay, it is, and there's a couple dimensions to it, going back to like this notion of the moratoriums, like particularly the ones here in Seattle say that, not only can they not evict, but landlords can't charge interest on back rent and they can't charge late fees. So, there's the government, the courts have set up courts have their 4-part test for these things. If you meet these 4 parts of the test, then it's okay. And in this one, their 4-part test includes things like, well, what's the nature of the situation that calls for this? Is the government response to this, does that actually address that situation or not? And then what they call narrowly tailored is it? Does it overreach? Does it do too much? So in this case, they look at things like the late fees and the interest and say, okay, if you're banning late fees and interest, is that really overstepping this? Or, at what point does the financial burden on landlords who still have expenses too become so large that continuing to, have this eviction moratorium in place and say, no, you can't bring in a new tenant who can pay anything, is just too burdensome for them, right? And by the way, don't read in any of what I'm saying here as to me choosing a side on this, right? Because this is complicated, and I'm trying to sort of present what's the strongest argument that both sides have on this. But it's
right. Well,
the tricky part is this middle of like what's too much here? What's too much for the government to do here?
What relief are the plaintiffs looking for? Are they just looking to be able to evict people and move on with life? Are they looking for financial damages?
They are just looking to evict people at this point. They want an injunction to basically void the moratoriums.
What do you think that would look like? In a city like Seattle, say if the plaintiffs win, if they get this injunction and they can start evicting people. I mean, how does that really play out on the street level, though? I mean, when like the sheriff actually showing up to people's places and evicting them, I don't see it being a pretty situation, at least in Seattle.
It's going to be. I mean, it's going to be ugly, right? And it's going to be ugly because we do have, still a pandemic, and we still have significant economic, downturn that's come out of this. There are still, there's still a very high unemployment rate in the city now, and it's going to be that way for a while, right? But again, that's sort of one of these, what's too much? The city council came in and the mayor said the moratorium is in place until the end of the emergency that she declared. The city council came in and said, now we wanted the moratorium to go for 6 months past the end of the emergency, right? Well, is that too much?
Well, there's some members of the city council who want just rent forgiveness. So
yeah,
they
so just coming back to these issues, the takings issue, right? This is why which is why at the federal level, at the state level, at the city level, this is why there have been no rent forgiveness, orders or legislation passed, is because that would almost certainly be a violation of the takings clause. That is textbook depriving these landlords of their economic value of their property, right? At least here they can say, okay, on paper you're still accruing debt, right? Those tenants are still responsible for the back rent, right? They'll have some time to pay it back, but eventually they're going to have to pay it back. They're going to owe that, right? Although still, it comes back to this notion of yeah, but if this moratorium went on for 10 years and they didn't have to pay anything back until the 10 years were up, that's probably too much. I mean, that's almost certainly too much, right? So, is not having to pay anything back until 6 months after the end of the COVID emergency, is that a reasonable thing for the tenants, and is that a reasonable thing for the landlords? Right. This is where it's going to get really tricky for the courts to kind of sort out.
Right. And now the firm that's pushing this forward, they're pretty, because people have been bringing lawsuits left and right, but the firm that's pushing this forward actually has a track record of they got some weight with them, right?
So this is the Pacific Legal Foundation. They are a champion of conservative legal causes. They're the ones who took on City of Seattle's fair chance housing tenant protection law and its first in time tenant protection law. They lost in the first in time one in the state Supreme Court, and the fair chance housing one is still moving forward, but it's not looking good for the plaintiffs in that one. But they've done a lot of these, and sometimes they win, and sometimes they lose. So they've got some very good lawyers in there. And so they're not somebody to, that should be, dismissed out of hand as they're just quacks out there doing this thing. Now it's interesting though, because, as a champion of conservative causes, you can look a little deeper in this and say, maybe there's something else going on here too, because, we have on the U.S. Supreme Court now. And by the way, this case was filed in federal court. So it's going to go up, from U.S. District Court to the Ninth Circuit to potentially the U.S. Supreme Court, and as opposed to going up through the state court system. And on the U.S. Supreme Court now, we used to have Justice Scalia on there, and Justice Scalia was known as what was called a textualist, where he believed that the only way to interpret the U.S. Constitution was the way the original writers intended it when they wrote it. It's not something you reinterpret to the modern times, right? It only means what it meant to the original writers when they wrote it, right? And this whole notion of the constitutional protection for impairing contracts is something that, starting with these rulings around the time of the Great Depression, started this kind of push to really expand kind of government emergency powers to constrain, these other fundamental constitutional rights. And, textualists will push back very hard on that. It's like, no. The impairing contracts meant this really specific thing. And they were very serious about, no, the government isn't going to, do things to impair contracts at the time the Constitution was written. And you don't get to reinterpret that for, our current view of, pandemics and other government emergencies. And, and so this Pacific Legal Foundation may be looking at this saying, hey, maybe this is something that, just as a conservative cause, we could get the textualists on the Supreme Court to actually bite on right now. So they may be, kind of salivating at the opportunity to get this in front of the U.S. Supreme Court for that reason. We'll have to see where this goes.
Well, so they filed it today. How does the process, especially right now, how fast or slow is this process of moving through the courts?
Yeah, so this is a case where basically none of the facts are going to be in dispute. So they don't need to have a trial. This one is going to get resolved on motions for summary judgment, where the judge basically, looks at the facts, and both sides are going to basically agree on the facts. They're going to have completely different arguments about what interpreting the law in this space, and the judge will interpret the law, make a ruling, and that'll kind of get appealed up the line from there. And depending that. My guess is, given that this is a fairly urgent thing for landlords to, in terms of kind of their income right now, they haven't yet filed a motion for a preliminary injunction, but my guess is they will probably in the next few days, and then that will get resolved probably in the next month or so, right? And then after that, they'll kind of do longer briefs and have a more in-depth legal argument about what this really means. And, I think it's hard to say, I guess I don't want to prejudge what the judge would say on a preliminary injunction. The threshold for preliminary injunction, it's another one of these, 4-part tests that the courts love to have. And, part of it is what's in the public interest, but a big part of it is how likely is, the side asking for it to succeed on the merits of their case. So the judge will have to look at the merits of the case and say, do I really think that the plaintiffs are likely to win this case or not?
Well, but how does it play out though if the judge is like, well, the plaintiffs have met their burden or agrees with them, but he or she, the judge has also balanced like what's going to be the outcome. You know what I'm saying? So it's like you rule in favor of the plaintiffs, like, okay, they've met the burden, but the judge is also looking at, well, man, thousands of people now very well might, get a pay up or quit. And you're looking at massive evictions in the numbers of hundreds or thousands of people.
Right. And so, and so let me just talk for a second about the other parts of this test, right? One part is, are they likely to succeed on the merits of the case? But then they look at the balance, what they call the balance of hardships, right? How much of a hardship is it on the plaintiffs if they don't get an injunction? And how much of a hardship is it on, the government or the public if they do get an injunction on this, right? So that's a part of it. And then, another part is what they call, what's in the public interest? Is it in the public interest right now to grant an injunction and basically, create, allow evictions to go forward? And I think that is going to be a difficult call for a judge to say, for the moment, we're going to allow evictions to go forward. I think there would be kind of just a huge tidal wave of evictions immediately if that happened. And but that's what the judge is going to have to decide, whether it's in the public interest to do this and where the balance of hardships lie between the two parties.
Right. And again, it's not the landlord who's going to enact the eviction. It's law enforcement who's going to come and evict. In Seattle, that's what the King County Sheriff is going to come and do an eviction. So, I mean, with everything that's going on here, what does that look like?
Yeah. And that's, a really interesting part of just going back to how the courts have ruled on these questions of how much power does the government have in emergencies? And one of the principles that comes out of this, which I thought was really interesting, was emergencies don't grant the government more power, right? But they create a situation where if there are powers that the government already has, that situation may call on them to use them, right? So in this case, the powers that the government have relate around just to what you said, right? The sheriff is the one who actually enforces evictions. They're the ones who show up and literally evict someone, right? So it's not the government sort of getting a new power in the case of emergency. It's how does the government choose to use the power it already has in an emergency?
And I mean, you very well in a city like Seattle or in King County, you very well might find the sheriff saying that, like, yeah, we're
Nope,
not
not
going
going
to
to do that.
evict.
Yeah, yeah.
And so then even though the landlords have won in court, there's still no arm there to actually enact the eviction. So
Yeah,
this could really be
they would actually have to go back to the court and get the court to issue the sheriff an order if the sheriff refused to say, no, you must go do these evictions.
This is real interesting. We're gonna have
Yeah,
to keep
it's
an eye on this one, Kevin.
yeah, it's this is you could kind of see this coming, right? But a lot of this is the moratorium has been in place for a lot of months now, right? And one of the plaintiffs said in the complaint that was filed today that they've got over $14,000 of back rent due to them. Another one has over $10,000 of back rent due to them, right? So we're not talking about small change here, right? It's not small change for the tenants, and it's not small change for the landlords either, right? It's a significant amount of money, and there are financial hardships for both tenants and landlords in the situation, right? So it's they're, while from a 30,000 foot point of view, there's very strong support in the case law for saying the government has the right to do this, right? When you get down to the specifics of exactly what these moratoriums say, there's some room for argument in there that maybe this goes too far. And I think really that's what, a lot of the debate in court in front of the judge is going to be. Does this go too far in some ways? Or has it been in place for so long now that it's created too much of a hardship on the landlords?
All right. Well, we'll continue to follow it up. Kevin Schofield, sccinsight.com. Thank you for taking the time to break it down into bite-sized pieces, man. This is going to be a big issue. I think we're going to be on top of this one.
Does your brain hurt? My brain's still hurting.
I told you it's been hurt. Hey, look, I'll catch up with you soon.
Okay.